The Massage Therapy Advisory Board meeting is now called to order. The time is 10:01. Board members, please remember to keep your cameras on unless we're in recess, and mute your mic unless you wish to speak. Okay, we have two new members that we'd like to welcome, Heather Nussbaum and Sue Croft. I don't know if they're here, but welcome to the board. We're happy to have you. And Anna, you're going to call roll, please.
Yes, ma'am. David Lauderstein.
Here.
Good morning, sir.
Hi.
Russell Rust.
Present.
Kara Willis is absent. Antonio Gracia is always also absent. Kitra Taylor.
Present.
Callie Morris. Oh, Miss Morris, I think you're muted.
Present.
Thank you.
Sorry.
Heather Nussbaum.
Present.
Sue Croft. You have a quorum, ma'am.
Okay, very good. Okay, we'd like to have Elizabeth Salinas Strittmeyer, the Assistant General Counsel, explain the General Counsel training, please.
Ms. Guerin, before we do that, did you want the board members to introduce themselves?
We could,
Since
yes.
we have, okay.
Since we do have a
David,
quorum.
okay, perfect. David Lauderstein, would you like to introduce yourself, sir?
Hi. I've been on the board for quite a while, and I'm the co-founder of Lauderstein Conway Massage School, and I'm a deep massage enthusiast.
Mr. Rust?
Hi, Russell Rust. I'm Hands-On Approach School of Massage. I've been the Law and Legislation Chair for the American Massage Therapy Association since 2001.
Thank you. Ms. Taylor?
I am both a massage therapy instructor and a aesthetics instructor since 2013.
Ms. Morris? Oh, you're muted, ma'am.
Sorry, Callie Morris.
Okay.
I've been with the board since I think it was 2022. And I have been working in the industry for massage and spa since 2007. I work at a Massage Envy location.
Nice. And Heather Nussbaum.
Hi, Heather Nussbaum. I own a New Beginning School of Massage Colleen with my husband. I'm new to the board this year, and I have been in or adjacent to the massage industry for about 20 years.
Thank you so much. And welcome to the board.
Okay, now we'll have Elizabeth.
Welcome, new members. My name is Elizabeth Salinas Strittmeyer. I'm the Program General Counsel, Assistant General Counsel for this program, Massage Therapy. And as part of your duties on the board, we do training on 3 important statutes that apply to board members and to the agency as a whole. Anna is very generous, and she is running my slides for us this morning. But this is what we call our open government training, and the focus of this training is to bring you up to speed on what your obligations and responsibilities are as board members in relation to your duties as board members and in relation to communications and information and transparency in anything that you do regarding the agency and work as an advisory board member. So what we are going to talk about are the 3 acts that I just told you we were going to talk about: the Open Meetings Act, the Administrative Procedure Act, which is also known as the APA, and the Public Information Act. And Anna, if you can go ahead and move the screen for me, move the slides. Okay, keep going. There we go. Okay, now, yes, that's correct. Okay, so the Open Meetings Act is the specific statute in our state that works to ensure that we have open and transparent government at all times. So what that means is basically that the act requires meetings of governmental bodies, which you are, to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting. And the provisions of the act are mandatory, not discretionary. So the things that the Open Meetings Act instructs us to do, we have to make sure that we carefully adhere to those things. So the key concepts of open meetings, and you can go ahead and go to the next slide, Anna, are a quorum. You've heard that word already used this morning. A quorum is a majority of the members of the board as fixed by rule or statute. A quorum of a governmental body, including an advisory board, you must meet in order to take an official action. If less than a quorum meets, you can meet to discuss, but you on the record, but you cannot take any official actions. And so let's go to the next slide. So what is discussion or deliberation? When you all have board meetings, you talk about the issues that have been noticed on the agenda and you engage in deliberation or discussion. But deliberation or discussion can be either a verbal or a written exchange among a quorum of governmental body or between a quorum of a governmental body and another person. So either verbal or written exchange amongst yourselves or verbal or written exchange amongst a quorum of yourselves and another person. And the applicability of the Open Meetings Act is when you are talking about an issue that's within the jurisdiction of the governmental body. So in plain language, that means that it has to be an issue that you can do something about or that is within your purview to discuss as a board. And so let's talk about the meetings. If you can go to the next slide, Anna. A meeting, and this is very important to remember, a meeting occurs anytime a quorum of a governmental body engages in a deliberation, which we just talked about, regarding public business or public policy over which the governmental body has supervision or control, or anytime the body takes formal action. So what's important to remember about this is meetings aren't just formally noticed board meetings. If you have a quorum and you engage in deliberation, that is considered to be a meeting. And that meeting would need to be publicly noticed and open to the public. So the important takeaway on this slide is to remember that anytime you have a quorum and you're going to discuss in deliberation regarding public business or an issue over which you have supervision or control, or anytime you take formal action, you have engaged in a meeting. All right, so I just said that anytime you engage in a meeting, you have to have notice to the public that you are going to engage in that meeting. And this again is for full transparency so that the public is aware anytime you're engaged in a meeting in which you are deliberating or discussing public business or business over which is under your supervision or control. So what is notice required? You may have seen a notice for this meeting. The act requires advanced written notice of the date, time, place, and subject of each meeting. So we put out a notice in the form of the agenda, and we file it with the Texas Secretary of State at least 7 days before our meeting, and it has to be posted online by both TDLR and the Secretary of State. And an important point to remember is that a board or a committee cannot engage in discussions about a subject that is not included in the agenda. So say, for example, you all had some public comments that occurred today. If the subject of those public comments are not on our agenda, you cannot talk about them today, but you could decide to talk about them at a future meeting. Okay, so we get this question a lot. What about when you're out and about at a social function or a convention and a workshop, professional development type stuff? So keeping in mind the point that I stressed earlier, that a meeting occurs whenever a governmental body, a quorum of the governmental body meets and discusses an issue within their jurisdiction. The question that's often asked of us can members ever meet in an informal setting without violating the Open Meetings Act? And the answer is yes. You can engage in conversation that is incidental, but the discussion will be subject to an Open Meetings Act inquiry and application if a quorum of members is involved and the members either engage in discussion or make decisions about board or committee business or take formal action. So anytime you're at any of these functions, you need to just stop and ask yourself, is this incidental to the event, this conversation that I'm having, or am I in a quorum situation where I am having discussions about things that are related to board business? So key points to remember. Be aware of any situation that you're in which a quorum of members is present or engaged in a discussion. Don't engage in substantive conversations relating to the board or policy when a quorum is involved and you are outside of an officially noticed and scheduled meeting. And always beware the walking quorum. The walking quorum is a very important thing for you to know about. And so let's talk about the walking quorum. It occurs when fewer than a quorum of members engage in a discussion about official business, and then you communicate those discussions to other members. While fewer than a quorum of members participate in the initial communication, the subsequent communication with other members will result in a quorum discussion outside of a public meeting. So when you are talking amongst yourselves, be very conscious of then going and talking to someone who wasn't a member of the board, who was not present when the original conversation occurred. Now, something to be aware of also is you got to be aware of transmitting those things in any form, transmitting those conversations in any form, and I'll talk about that in a minute. But let's look at an example. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have each individually performed regarding the issue. One of the board members subsequently forwards the exchange to another member, so to a member that was not originally part of that conversation. Now you have 3 people who have engaged in discussion about this issue, and you have engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed meeting, because adding that third person, looping that third person into the conversation kicks you over into a quorum where 3 people out of 5 have now been involved in that discussion. So when can walking quorums occur? They can occur during conference calls, video conferences, hallway discussions, emails, text messages, and other new technologies. And yes, they can also occur on social media. So be very conscious of your conversations and conscious of these walking quorums that can accidentally occur anytime you are talking about board business, regardless of the situation, regardless of whether it's by phone or email or on social media. Beware of the walking quorum. How do you avoid a walking quorum? So in order to avoid that, you should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. You should not send emails or text messages to a quorum of members regarding official business. Even if each email is addressed and sent to each member individually, it still counts as looping someone into the conversation, even if it is a separate email or separate invitation. Do not create posts on social media about board business where a likelihood exists, even just the likelihood, that a quorum of members could participate in discussions. And do not ask a quorum of members, even on an individual basis, for feedback or comments on board or committee business outside of the public meeting. This is called polling, which is essentially conducting an informal vote on an issue, and that would be considered a walking quorum in violation of the act. Now, for open sessions, I've already mentioned one part of this is that you are limited to discussing the specific items on the agenda. When there's public comment and people make comments, if they're given an opportunity to speak and make their comments, the presiding officer, in this case, Ms. Guerin, may set reasonable limits on the commenters. And if you want additional discussion on reasonable limits, I'm happy to take any questions from you all at the end of our presentation. A member of the public or a member of the board may raise a subject that is not on the agenda. But as I said, at the top of this discussion, any discussion about that subject must be limited to a proposal to place it on an agenda for a future meeting where you can then have a full and robust discussion on that issue. Guidelines for open sessions: to avoid violating the act on the basis of insufficient notice, members should limit discussions to the specific agenda items contained in the posting filed with the Secretary of State. We have a theme going here, right? If it's not on the agenda, we can't talk about it. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that haven't been noticed to the public. Sometimes that can happen when you're talking about one issue that is dovetailed with another issue, and we watch out for that when we're in the public meetings. Program staff and myself, we specifically watch for making sure that we're not wandering off into new issues. So sometimes it happens. It's sometimes a natural thing to happen, but be conscious of that. But we will try to bring it back to the agenda if we need to. You should not respond or discuss issues raised during public comment that are not on the agenda. And at the end of the meeting, you'll have an opportunity to specifically identify items for future agendas to us. And we can look at putting those on the next agenda for our next meeting. Because this is a statute that's applicable to everyone, there's obviously civil remedies. Any interested person, including the media, may petition the court to stop actions taken in violation of the Open Meetings Act. That is so very important to remember. If you are not in compliance with the Open Meetings Act, if walking forums have occurred, if your notice is not correct, any interested person, and we'll get to the definition of an interested person, can come in and say, no, the decision that you made during that meeting is not in compliance, and we want to make that act voidable. Meaning it never happened. It never happened, and you guys can't take whatever action you decided to take. All right, so there are also criminal penalties that are attached. If you knowingly participate in a walking forum, or you knowingly participate in a meeting that is closed to the public, there are misdemeanor criminal penalties of $100 to $500 fine, confinement in county jail for 1 to 6 months, or both the fine and the jail time. So our best practices are avoid communications, again, that involve a quorum of board members about official business outside of a properly noticed public meeting. And during open meetings, you should confine your discussion to items that are specifically posted on the agenda. And again, we will help you stay on track. If you would like to know more about the Open Meetings Act, here are some resources. The AG's office has a wonderful handbook that they publish every year on their website that goes into great detail about the Open Meetings Act and what is applicable, what is not applicable. And if you want that, we can provide you, we can email you the link, but it's here up on the screen. Let us know, and Anna can get that to you if you actually want to go onto their website and to look at it yourself. So the second act that we're going to talk about is the Administrative Procedure Act, also known as the APA. And the purpose of the APA is to establish minimum standards of uniform practices and procedures for state agencies. So to create a system that all state agencies adhere to, and to provide for public participation and transparency during the rulemaking process. And this is very important because we at TDLR pride ourselves on our transparency, first and foremost, and especially our transparency during the rulemaking process. And the APA in rulemaking, the APA definition of a rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes a statement regarding only the internal management or organization of state agency and not affecting private rights or procedures. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. And how do we engage in rulemaking? Well, our sources for rulemaking are through legislative changes. After we have a session, we will look to see if there are any statutory changes that impact the massage therapy program. And if there are, then we engage in what we call bill implementation teams. And one of the jobs of the bill implementation team is to say, okay, here's the legislative change. Do we need any rules in relation to that legislative change? Keeping in mind that not all legislative changes require rulemaking, but TDLR will always examine legislative changes to ensure that if there is a need for rulemaking, that it gets done. Another source of rulemaking is you all, the advisory boards. You all are our eyes and our ears and our experts on the ground, who are licensees. You know what's going on in your industry. So advisory board members will and do propose rulemaking. We also get proposals for rulemaking from staff. Our different divisions have input on rule amendments or rule changes, and I always make sure to include those voices because they are an important part of the rulemaking process, and their input and how the rules play out on the ground is very important to the rulemaking process. We also have a 4-year rule review where every 4 years we go through a comprehensive review to determine if the rules need to continue to exist. And if the rules do need to continue to exist, there's 2 phases to our rule review. The first phase is we adopt the rules. We just re-adopt the rules in their current form. And we do that through the commission. The commission will re-adopt those rules in their current condition, in their current position, their current iteration. Sorry, I couldn't find the right word for that. In their current iteration. And then in phase 2, we will go through and take all of the input that was given to us during the 4-year rule review, which includes input from licensees, input from board members, input from division staff, things that the program GC myself have noticed that might be a problem in the rules. In phase 2, we look to see if, okay, in response to the concerns that were raised during phase 1, do we need to go into rulemaking to address those issues? And there's also a rule petition. A member of the public can issue a rule petition lobbying for a new rule and asking us to adopt a new rule on a specific subject. And there are specific procedures related to that we have to follow when we receive a rule petition. It's not common that we will receive a rule petition. It does happen. During my time on this particular program, I do not believe we've ever received a rule petition, but on the other programs that I also in the GC for, we have received rule petitions. So a lot of it just depends on the program and how active people are and whether there are issues that are really hot button issues. Sometimes those are the things we see being pushed as a rule petition. Now, a rule petition can be, as I mentioned, can be sent in by any interested person. Well, what is that? Who is an interested person? There's parameters. They have to be a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency, but is located in Texas. So on that point, think about your professional organizations. Professional organizations are considered to be interested persons. Okay, so I love this slide because I think it really shows you the depth of what it takes to make a rule. Now, I will say at the beginning, it generally takes 9 to 18 months from the time we start working on a rule to the time that we ask the commission to adopt it as written. And there are a whole lot of things that occur during that time frame. And a lot of people don't realize that to draft a rule or to engage in rulemaking takes a long time, and it takes a lot of people who are involved in it. So let's run through that. So you start with the rule idea and you start with drafting a rough draft. You go through your internal review and analysis. And in the internal review, it's reviewed by division staff. And if you have a rules work group for the advisory board, which this board does, that also includes the rules advisory the rules work group. They will have input into the drafting of the rule. After internal and board and GC are comfortable with the draft that we have, we send it off to the governor's office for review. And the governor's office will either send it back to us saying it's ready to go, or they will send it back with comments and concerns or questions asking for rewrites. Then we will respond to whatever the governor's office has asked us to respond to, and we will have our first advisory board meeting. That is the first look for the advisory board, licensees, and the public to see what the proposed rule is. And during that meeting, someone will make a motion to either accept the rule draft as written or with changes. There will be a long, robust discussion of whether there needs to be changes. If there need to be changes, we can do that on the fly during the first advisory board meeting. And then the question will be asked of whether you want to go ahead and send this out for public comment. If you decide to send it out for public comment, then we file those rules with the Secretary of State with our plain talk summaries. And we also send those proposed rules over to the Texas Register, which then initiates a 30-day public comment period. Any member of the public can comment during that period. And when that 30-day public comment period is over, we do a review of every single comment that comes in during public comment. Every single comment is reviewed by a number of people and discussed within the agency. And sometimes during the public comment period, we will get people who aren't commenting on the rule, but they're commenting on an issue or a problem that they may be having. What we do with those comments is we send them to the appropriate division for handling. And then after all those public comments have been reviewed, we go to a second advisory board meeting where I present you with all of those comments and with TDLR's response to those comments. And then you will take a vote on whether you want to adopt the rule as written after hearing those comments or whether you want changes. If you go ahead and decide to adopt, we send an adoption notice with the Secretary of State and we publish it in the Texas Register. And then we have an effective date of the rules. Now, we also in here have to present that to our commission. And so our commission actually, we present it after everything's been said and done, we present it to the commission and the commission is the final adopter. But typically, if a board has voted to adopt the rule or the change or the repeal, the commission joins in that decision and will give us authority to make it effective. Now, I mentioned to you that our rule review process is on a 4-year rule schedule. So here is what that looks like. We will notice of intent to review. The public has 30 days to comment. I will review the comments and make a recommendation to the commission. The commission reviews the filings and may readopt the rule. The advisory board will be presented with any comments and may recommend changes. So this actually, the green box, that is phase 2. So what you see here from the teal oval all the way to the blue oval is to get this in front of the commission. But if you notice, we are gathering input here with 30 days to comment. And then in phase 2, that is where actual rulemaking will occur. So rulemaking, we also have some resources if you'd like those from both the Office of the Attorney General and the Secretary of State. And there's also a number that you can call. Sorry, if you want to talk to our office, if you want to talk to me about rulemaking, you can go ahead and give me a call, or really honestly, the easiest way to catch me is through email. So then the final act that we have is the Public Information Act. And the Public Information Act, also known as the Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. And so what does that mean? What does the act do? It makes all documents, records, and other information relating to official business open to the public. But there are some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official business, agency business. I would like to stress this, on any device. So if you are communicating about official TDLR business on your personal phone and we get an open records request, you will have to turn over the communications that exist on your personal device. I just want to make sure every board member understands that, because that's a very important point to remember about the PIA. And another important point that goes along with that is the PIA is construed liberally in favor of granting requests for information. So assume that any document you produce during the course of your service where you're discussing TDLR related business is potentially an open record, and it is potentially subject to an open records request. All right, but how do you do an open records request? You have to do it in writing. So a member of the public can request copies of public information or request to inspect the information in our offices, but the request must be in writing. We also require that the written request be submitted through our TDLR Records Center, and there is a link on our website that you can submit open records requests through. And then what do? What is our obligation? Well, we have to respond pretty quickly. We respond as soon as possible, but not later than 10 business days after receiving the request. So as soon as an open records request comes in, our open records attorneys immediately begin looking at that, gathering responsive documents, determining whether there are any objections that they can make to release of those documents, and we are well on our way to complying with the open records request. We cannot ask why someone wants the records. We can only ask for clarifications. So if you submit an open record and you get a question from our open records team, that question can only be clarifying your record, clarifying timeframes, or clarifying something within the written request, but we cannot ask you why you want that information. Okay, so what are our rules or our exceptions to disclosure? Remember I said earlier that we have the presumption of openness. We have the presumption that any communication that we engage in is potentially subject to an open records request. But the Act also contains specific exemptions that we are allowed to redact from our open records. So an example would be personally identifying information such as dates of birth, most email addresses, and I say most because there's a specific way that we determine whether the email address is or isn't subject to Open Records Act, or I'm sorry, the Public Information Act. The driver's licenses, license plates, and VIN numbers we will redact. Credit card numbers or bank account numbers will redact, and HIPAA information, that is protected health information that is subject to the Texas Medical Records Privacy Act. Now, anytime we seek to withhold those records, our open records attorneys must seek a ruling from the Office of the Attorney General to redact or withhold other information. So the specific exemptions in statute, we do not have to brief to the Office of the Attorney General, but if we believe something else is confidential, say for example, it includes attorney-client communications, we would have to brief that through the Office of the Attorney General, and that will slow down our response time, but our attorneys will always let the requester know that we have sent a brief to the Office of the Attorney General to seek guidance on whether we can or cannot withhold specific information. So what do you do if, as an advisory board member, you receive a request? So remember, it's only an open records request if you receive a written request for the records or correspondence. But if you receive a written request for records or correspondence that you even think sort of looks like a public information request, but may not exactly be a public information request, you're not sure, send everything over to us that you think is a written request for records or correspondence. And then that will be forwarded to the advisory board team, who will forward it to me. or I'm sorry, to the General Counsel Open Records team. They will be the ones to coordinate response to those records, which means they will be the ones in charge of gathering those records. So if you as an advisory board member are contacted by our GC Open Records team and they need you to look for specific information, please do that as soon as possible, because remember, we need to respond within 10 days. And that applies to all requests. And of course, we have additional resources for you all. And there is our number for the GC's office again, if you want to contact me directly. But again, easiest way to get me is through email. But I will gladly return phone calls as well. Okay, so that is the end of my presentation. And now I will turn it back over to you all. Do you all have any questions or clarifications that you'd like to ask me about? Wonderful. Okay. Well, new board members and longtime board members, if you think of something after the meeting, feel free to reach out to me. And I will
Thank
now
you,
turn
Elizabeth.
to Ms. Garrett.
All right, thank you. Okay, the next on the agenda is the approval of the minutes. Do any of the board members have any comments regarding the minutes of September 11th, 2023? No? Okay. I ask for a motion to approve the minutes. David, are you shaking your head? Okay, you're on mute. David, you're on mute.
I do approve of the minutes. Thank you.
Okay, can I get a second?
I'll second it.
Okay, thank you, Kit. Okay, board members, when you speak, would you please introduce yourselves again so that they have it on record? Okay?
David
Okay, the
Lauderstein.
next, oh, go ahead, David.
That's me, David Lauderstein.
All right, thank you, David and Kit. All right, public comment. The Massage Therapy Advisory Board has received one written comment that was emailed to the board members yesterday afternoon and will not be read during this meeting.
Ms. Garrett, let me go ahead and do a roll call vote for the minutes.
Okay, very good.
Thank you. David Lauderstein?
Yes, accept them.
Russell, thank you. Russell Rust?
Accept.
Kitra Taylor?
Accept.
Callie Morris?
Accept.
And Heather Nussbaum?
Accept.
The motion passes.
Okay, very good. Thank you.
Thank you.
Okay, next we have Leonard Rivas, the manager, to make his presentation on the staff reports.
Good morning, advisory board members. My name is Leonard Rivas. I'm the licensing manager for the massage therapy program. Welcome to our new board members for participating today. You have a copy of the licensing statistics in front of you. I won't review the entire report. I will go over the second quarter for fiscal year 2024 with you. For massage therapists, for the second quarter, we issued 692 new licenses. We renewed 3,895 renewals. And then for massage therapists, for the total population at the end of the second quarter, 28,401. For massage therapy instructors, we issued 44 new licenses. We renewed 198. And the total population for massage therapy instructors for fiscal year 2024 second quarter was 1,573. For massage therapy establishments, for the second quarter, we issued 212 new licenses. We renewed 320, and the total population for massage therapy establishments at the end of the second quarter was 3,091. That concludes my report for the licensing division. I'll be happy to answer any questions. All right, thank you.
Okay, thank you, Leonard. Okay, next we have education and examination with Ann Pascal, the program specialist.
Good morning, advisory board members. My name is Ann Pascal. I'm actually a team lead within the Education Examination Division, and I'll be providing our report today. As you can see, our report will provide a comparison between fiscal year 2023 and 2024. As of March, the end of March, our continuing education providers for the massage program was 371. Jurisprudence examination, we had 108 candidates complete the JP exam. If you could scroll down there. There we go. Thank you. The examination, massage therapy examination is doing very well. As you can see, we are at a 72.4% overall passing rate compared to last quarter, or fiscal year 2023 at 63%. So it's doing very well. And then massage school, hopefully the same. We have a total of 69 as of the end of March for fiscal year 2024. And that concludes my report. I'm available for any questions that you may have.
Okay, and I have a question, please, Caroline Guerin.
Yes.
Is this the passing rate just for the exam for Texas?
Yes.
Okay, we don't have the minutes, or we don't have the information for the NBLEX?
No, we do not provide that information.
Okay, all right, very good. Thank you.
You're welcome. Thank you.
This
Okay,
is that.
Yep.
Sorry, Caroline. This is Heather Nussbaum. When we're looking at these pass rate numbers for each quarter, is that total overall pass rate multiple attempts, or is it first time?
This is overall pass rate, so multiple, correct.
Thank you.
You're welcome.
Okay, anyone else have any questions? Okay, next we get to the Customer Service Division with Patricia Martinez Castelman, and she will give her report.
Good morning, advisory board members. I'm Patricia Martinez Castellan, the customer service manager over the massage program, and I'm here to share statistics for fiscal years 2023 and 2024. As shown on the report, our numbers have remained consistent, similar to the previous year. There's a noticeable seasonal peak in customer interactions with higher volumes around this time that may pertain to graduation rates and new student applications. We do track license status inquiries to ensure that our applicants and licensees are responded to promptly and receive the assistance required. For the most part, that concludes the Customer Service Division statistic report. Please let me know if anyone has any questions. Thank you.
Okay, does anyone have any questions? Okay, moving on, we have the Enforcement Division with Jessica Hurtado, the senior prosecutor.
Good morning, advisory board members. I am Jessica Hurtado, senior prosecutor with the Enforcement Division, and I'll be presenting the Enforcement Division's report today. As you may have noticed, we have updated the format of this report since your last meeting, and we hope that this new format will allow you to more easily compare the various statistics across fiscal years. And it's important to know that these numbers represent the time period beginning September through February for both fiscal year 2023, which began on September 1st, 2022, and for fiscal year 2024, which began on September 1, 2023. At the top, we have the division's performance measures, which are reported to the legislature. In good news, the average time for closing cases in your program has decreased significantly by approximately 85 days, and the percentage of complaints that are closed within 6 months has also increased by about 7%. The next section details the criminal history review statistics. And you can see that so far in fiscal year 2024, out of over 2,200 applicants, only 6 of those were ultimately denied a license or had their license revoked due to their criminal history. The next section details where our complaints come from either consumers or from other divisions within TDLR. And on the next page, you'll see this information in a pie chart. These are the cases that were opened. And the next section shows a breakdown of caseloads in enforcement. Under orders issued, you will see that so far for fiscal year 2024, there have been 65 agreed orders where the respondent admitted they made a mistake and paid an administrative penalty. Under penalties and consumer remedies, you will see that the amounts of penalties that have been assessed and collected. Next is the license sanctions section. These are licenses that were either suspended or revoked based on violations of the laws or rules for your program. And on the next page, you'll see cases closed without disciplinary action. These are ways in which a case may be resolved without a penalty or a sanction. And next you will see violations at opening. These are the reasons that a case was opened. And the next section details the violations that resulted in some type of disciplinary action. So that was either a penalty or a sanction. There are 2 case highlights for your review. And finally, complaint prioritization is a project that enforcement has recently completed at the direction of the Sunset Commission. Each of our cases is now reviewed and assigned a priority level based on the risk posed to consumer harm or to public safety. And the goal of prioritization is to focus our limited resources on those cases with the highest priority because they have the greatest impact on public health and safety. And that concludes my report. I'm available to answer your questions. Thank you.
Miss Guerin, did we lose you? I don't see her camera is on.
Yeah.
Well, if y'all would like, we can take a short recess while I try to find Miss Guerin in the interwebs. Let's meet back at if y'all like 11 o'clock. That gives us 12 minutes. Thank y'all so much.
Sounds good. There you go.
Awesome. Thank you so much.
Okay, I apologize for that. It was like boom and everything went out.
Boom and
But I'm
boom.
back. You don't know, but we did get it. I got a notice on my phone, an advisory for flash flooding. Did you get one, Callie? Yeah.
Yes.
So,
and my
okay, well,
yard
next
is
we
already
have,
flooding.
we have the compliance division with Jerry Gonzalez. Nice to see you.
Likewise. Good morning, board members, and welcome to the newest board member, Heather. My name is Jerry Gonzalez, and I'm here to present the staff report for the compliance division. Our current projects right now is, staff are still participating in the strategic planning that you'll hear a little bit about later in the board meeting, and it's our opportunity to add comment and see where we see the profession, our rules, the agency in 5 years down the road, and what we can do to better get ourselves aligned with what we need to do and what to expect down the future. So we're really looking forward to processing all the comments that they got through the strategic planning and see what direction the agency will be headed or need to go. We continue staff to help other divisions with questions regarding investigations, inspections, and general day-to-day inquiries that we receive from licensees, from public members, from law enforcement throughout the state. As far as our outreach program, or outreach event, excuse me, we attended, staff or myself and our anti-trafficking team had 2 presentations that we provided that I was with them in city of Lake Jackson and Amarillo, where we provide a presentation regarding the massage program, an overview of the program in general, our inspection process, our complaint process, red flags and things to see and look for in some of the settings that they have to go out and look at. And also in March, we attended the International Congress of Aesthetics and Spa Show, ICES. And don't let the name fool you, even though it's primarily for estheticians. There was a lot of massage therapists there, both licensees and staff, or excuse me, members trying to be licensed and what they needed to open up a massage business. So we had a lot of questions for the barber cause program, the laser hair removal program, and a lot for the massage program in this show. And speaking of outreach, if you know of any events or seminars or association gatherings or anything that you would like for us to attend, be it virtually or in person, please feel free to contact me and we'll make every effort to attend those shows. And that concludes my staff report, and I'd be happy to answer any questions that you may have for me.
No questions? Thank you, Jerry.
You bet. Thank you.
Oh,
This is
Russell
Russell
has a
Russ. Could I
question.
ask a
Jerry,
question?
Russell has a question.
Not for Jerry. We didn't get to talk to enforcement division. We didn't answer any questions. I was just wondering, we didn't finish up with enforcement. That's when we lost you.
I think, Russell, if I'm not mistaken, Jessica asked if anyone had questions and no one raised their hand, but that's also when we lost Carolyn. So I believe it was just Carolyn.
That's okay. Then we can move on. Thank you.
Yes,
Okay,
sir.
there will be she's coming back, so you can ask her questions then. Okay, now we have Fernando Reyes, the manager for the Field Inspection Division.
Good morning, board members. It's great to see you all again and hear from you. My name is Fernando Reyes. I'm the South Region Manager, and I'll be providing you with our Field Inspections Division report this morning. Going into it, below you'll see the stats. These stats are inspections completed, cover fiscal years 2023 and 2024, up until second quarter of March. I just want to highlight the inspections completed quarter 1 from 400 to 463. That was a 13% increase. And quarter 2 of 2024, 174 to 361. That was a 51% increase in those inspections completed for this fiscal year 2024. If you have any questions about the stats, I'd be more than happy to answer those.
No questions?
All right.
Okay, thank you.
Just a couple of things. Current projects. As you all may or may not have known, our previous inspections director, Eric Beverly, left TDLR and accepted a position as the executive director for the Sunset Commission. We wish him well in his new role and thank him for his service to the Field Inspections Division, TDLR, and especially the citizens of Texas. On October 16, 2023, Chris Russi was selected and assumed the role of Field Inspections Director. Mr. Russi brings a wealth of knowledge and comes from us from the TDLR's Compliance Division, formerly RPM, where he served as manager over the Consumer Protection section, and this included 13 different programs related to consumer protection. Under his guidance, field inspections will continue to move forward and thrive in serving the citizens of Texas. Highlight a big kudos to our training section. That includes our liaisons, our senior trainers, and everybody who participated in training. We recently trained 3 additional inspectors in the massage programs, and these additional inspectors will assist us in strengthening our regulatory compliance and public safety. Also, if you refer back to the stats on Q2 of 2024, that big increase is a direct result of adding those folks to the program and training those inspectors. So there's not any questions. That's all I have for my report for the Field Inspections Division.
Okay. Thank you, Fernando.
Thank you.
Okay, next we have the Executive Office with Steve Bruno, the Deputy Executive Director.
Good morning, Madam Chair and Advisory Board members. This is Steve Bruno, Deputy Executive Director with TDLR. It's very good to be with you this morning. Quick update on personnel first. I'll begin with me. I'm new in the Deputy Executive Director role. I was formerly Government Relations Officer and Legislative Director. I've been Deputy Executive Director for about 8 months now, and I have the privilege of working with the divisions of licensing, customer service, and education and examination. Joining me as Deputy Executive Director is Brandy Myers. Brandy was previously our Director of Financial Services. We also have an interim Executive Director, a name that's familiar to many of you, Mr. Brian Francis. He was appointed at the beginning of this year to be interim Executive Director for a period of up to 6 months. Bill implementation update. I know that you all will be discussing some things in a little bit on Senate Bill 483, the main legislation that impacted your program. So I will save that for the next agenda item following staff reports. And then I wanted to talk a little bit, it's been mentioned, our strategic plan update. We're in that period of time where every agency is required to put together a strategic plan. We've been out on the road. We were able to visit 4 cities. And we also took comments online and held a virtual session. And I wanted to first thank everyone who came out and shared comments with us. Strategic planning is an excellent time for us to interact with licensees and do our best to improve our services to you all, to those we serve, so that you all can in turn help serve all of your clients. Our strategic plan is due on June 1. And after that time, you'll be able to find a copy of it on our website. And I invite you all to review that once it's posted. I am happy to take any questions or comments.
No questions.
All right. Thank you so much.
Thank you, Mr. Bruno. Okay, next we have Jessica Hurtado again, the senior prosecutor, discussing the possible action regarding the updates to the TDLR criminal conviction guidelines.
Thank you. Yes, board members, Jessica Hurtado, Enforcement Division. I am going to go ahead and share my screen so you can see. Okay. Okay, so I will be presenting the proposed criminal conviction guidelines for the massage therapy program. And as some background information, Chapter 53 of the Occupations Code allows the department to deny or revoke a license if that person has been convicted of an offense that directly relates to the duties and responsibilities of the licensed occupation. And the department is required to adopt these criminal conviction guidelines that specify which offenses are considered to be directly related for each program at TDLR. Each program has its own specific set of guidelines that are tailored to their industry. And these guidelines assist the department by specifying which crimes that our prosecutors should be focusing on when they're reviewing someone's criminal history. The guidelines also give notice to the applicants and licensees as to what crimes are considered directly related to their occupation and the reasons why. And as you know, last session, the Texas legislature passed Senate Bill 483, which removed the automatic bar to licensure for someone who has been convicted of or placed on a deferred adjudication for prostitution or another sexual offense. And so I'll just scroll down to that section here. So you can see the changes have been made to reflect that under this category. Importantly to note, the department will still consider whether someone's past criminal history involving prostitution or another sexual offense makes them ineligible for a license. And that determination is made after considering many factors that are listed in Chapter 53, including the age of the person at the time the offense occurred, how long ago it was, how extensive their criminal history is, and other circumstances. So this change just merely removed that automatic or that required portion. Okay, I'm going to scroll down to the second change. The second change is under this category, crimes involving human trafficking. The change here makes it clear that a conviction or a deferred adjudication for an offense related to trafficking will result in automatic revocation of a license under Section 455.251 of the Occupation Code. And that was also a change that came about from that Senate bill. The advisory board's work group met last summer to go over these proposed changes in the guidelines. And the next change was made at the suggestion of the work group members. I'm just going to scroll to that. Okay, and it's this last category, or this category here, crimes involving racketeering, organized crime, criminal influence, or money laundering. And the rationale for adding this category is that operating a massage establishment would give someone with this type of criminal history the opportunity to engage in further criminal activity of the same type. The last change I will scroll down to is from the 2019 session. And actually you won't even see it here because it was completely removed. It was related to an automatic bar for certain criminal violations of Chapter 455 of the Occupations Code within the last 5 years. And so that was just a cleanup change that we've made here. That concludes my presentation. I ask that you recommend these criminal conviction guidelines be for adoption by the Commission of Licensing and Regulation, and I'm happy to answer any questions. Thank you.
Russell Rust.
Yes, sir.
Now, are we discussing part of Senate Bill 483, or have we not gotten to that yet?
Well, we're discussing it as
That's
it
what we're
relates
doing it
to the
now.
criminal conviction guidelines. So,
Okay, what I want to get clarification on is the people that are coming in from other states, and I know their laws may not say the exact same thing. Are we going to use the words that are written in the other states' laws to determine whether they're in our penal code 20 or 20A?
so that's a great question, sir. What we do is we look at the statute of that state and look at the elements of the crime, and if those elements sufficiently match up to our own penal code, then yes, we will consider that to be a same or similar offense.
Okay, but that gives y'all the authority to do that. There wouldn't be anything that they could take you or try to justify or expulsions or anything like that as well.
I mean, we would make our best effort, sir. I don't know that it has been tried yet, so I can't really speak to
Okay.
what would happen.
No problem. Thank you. One other question on complaints. I know there's statutory requirements of what the complaints are. Does a complaint that is anonymous compared to someone that actually put in their name get treated differently?
Under our prioritization schedules, yes, some anonymous complaints are treated differently, but if it's alleging a serious health or safety risk, then that complaint is still going to be opened regardless of it being anonymous or not.
Okay, thank you.
Sure. Any other questions?
Okay. Thank you, Jessica. Okay, if there's no other
Ms.
questions.
Karen, I believe you need to take you need to ask if there's
Yes.
a motion to adopt.
I need a motion to adopt the criminal conviction
Rust,
guidelines to the commission.
Russell Rust, I make a motion to accept.
Okay, and do I have a second?
I second.
Kit Taylor, I
Gracia.
make.
Okay, Kit, thank you. Kit Taylor, second. Okay, Anna,
Take a
would you
vote.
do a roll call for the vote, please?
Yes, ma'am. David Lauderstein,
I agree. I accept.
Russell Rust,
Aye.
Antonio Gracia,
Aye.
Kitra Taylor,
Aye.
Kelly Morris,
Aye.
Heather Newsbaum,
Aye.
and presiding officer Caroline Guerin.
Aye,
Motion passes, ma'am.
thank you. Motion passed.
Mhm.
Okay, next we have Lorraine Struff. She will give an overview of the PALM system. Oh, Antonio, do you have a question?
No.
Oh, okay. I thought your
No,
arm was up.
No, I have. No, I have. I'm sitting in the car and I got my hand on the rail thing.
Oh, okay.
Ms. Karen,
Very good.
Ms. Karen, can we please
Yes.
describe what Ms. Ruff's going to be addressing as stated on the agenda?
Okay, I didn't hear you.
Can you please more accurately describe what the next discussion is based on the agenda?
Sure. It's the discussion regarding the ability of licensed massage schools to report and record the earnings of credit fractions in the PALM system for massage therapy students earning credits in increments. Thank you.
Good morning, board members. My name is Lorraine Srofe, and I am the Education Services Manager with the Education and Examination Division. I am here to help explain the process of reporting hours, and currently schools can report hours using whole numbers only with no decimals or no fractions. First, I just want to bring your attention to the requirements of the schools in regards to reporting hours. A school is required to collect and track the number of hours a student completes on a daily basis, and then report those total completion of hours to the department using the PALM system on a monthly basis. Currently, schools can only report hours in whole hour increments. The system where we collect the hours from the school is actually two systems. We have the Versa system, which was inherited from DSHS when we took over the massage therapy program. And then we have the PALM system, which is actually an interface system that schools use to actually report those hours, which then uploads those hours into the Versa system. This system that we inherited from DSHS was a old and outdated system with limitations that require programming if any changes are made to that system. And this particular issue would require programming. I am in the process of collecting data, which would determine the time, the labor costs that would be required, and the all of the data as in what would be required to make those programming changes to the Versa system, and which would also require changes to the Palm system as well. Once I have that information available, I will be glad to provide it, excuse me, to the board, explaining what that would require to make that capability possible to the schools. If you have any direct questions related to the collecting of hours or reporting of hours, I'd be happy to answer those. I would also like to take this time to point out that currently on a monthly basis, schools are making out errors when reporting hours. I want to stress the importance of accuracy when schools report hours to us on that monthly basis. If corrections need to be made, we collect documentation as verification and we can make those corrections. But it is important for schools to ensure that they are collecting and tracking the correct data on each student that is enrolled in their program. Thank you.
Russell Rust.
Okay, thank you, Lorraine. Does anyone have any questions for Lorraine?
Russell Rust.
Good morning, Russell.
Good morning. Is, when you say Versa, is that the new program that's developed for the massage industry, or have we not gotten to our own programming yet?
That's a good question. We are in the process of creating and establishing a new licensing system that will be across all boards and programs for the department. However, as I'm sure many of you all know, that is a lengthy process. Versa is not the new licensing system that's available for massage. That is the old system that we inherited from DSHS.
Okay, no problem. I just never heard that word. Now, the last time we spoke, y'all were looking for vendors. Has a vendor been established for doing this now? So it is in the process?
We are in the process of evaluating the current bids that we have received. And so once a determination is made, that information will be shared.
Okay, does the allotted money run out if y'all don't use it by a certain time, or is that an endless appropriations that we can use?
Mr. Rust, respectfully, this is now veered off from the agenda item. If you would like to have this
Okay,
discussion.
no problem. Thank you.
Agenda.
Excuse me.
Okay, any more questions?
Yes.
Yes, David.
So just to be clear, is there any progress on reflecting less than whole number, so fractions in terms of completion of hours?
Good morning, David.
Hi.
As I said, I am in the process of collecting data as to what would be required to make those programming changes. It would be programming changes to the Versa system and then programming changes to Palms itself. So it would be two different systems that would require programming and updates. So I'm in the process of collecting the data to determine what the time and labor costs would be involved to make those changes. I can tell you that in the new licensing system, once it's established, you would be able to have that capability because that request was already included.
Okay, thanks very much.
You're welcome.
Okay, any other questions?
Heather Nussbaum. I just for some background for myself, what is the impetus in the request to do the reprogramming for the fractions versus just entering the rounded down to the last whole number?
Can you explain your question just a little bit more,
Yeah,
Heather?
sure, no problem. So what is the reasoning behind the why behind doing the reprogramming to be able to do fractions versus if a student has, 19 and a half hours, not entering 19 hours until they get to the 20-hour point?
I know that with most schools, a lot of you use time clocks and other programs, online systems, security systems to track hours. And when students clock in and out, as you know, most of the time it is not in a whole number. And so schools are still required to track the number of hours completed. But since the system only has the capability of collecting the whole hours, you're not able to fully enter and report the actual time a student is completed. So we do stress again the importance of accuracy. And because of the limitations of that system, you're not fully capable to do that. So the programming that would be required would allow you to be able to report the actual time, including hours and minutes, that each student completes on a monthly basis. So first, to make those programming changes, I have to collect the necessary data as within regards to the time and labor costs to determine whether or not that would be a feasible investment for us to make those changes when we're also in the current process of establishing the new licensing system. Does that answer your question, Heather?
Yeah.
Okay, thank you.
Okay, thank you, Lorraine.
Absolutely. Have a good day, everyone.
Thank you. Next, we have Elizabeth, who is going to discuss TDLR's review of massage rules in the Texas Administrative Code, Chapter 117, Massage Therapy, including an update on the rules work group involvement and plans to prioritize possible rule amendments.
Good morning, Elizabeth Salinas, Strip Matter again with the General Counsel's Office. So the update that I wanted to provide you all is to let you know that for the past approximately 6 months, myself and another attorney who I asked to assist me, Jonathan Parker, who's also an assistant general counsel, have been looking at the massage therapy rules to see if there needs to be any cleanup prior to this coming legislative session. And as you know, if we have bills coming out of a legislative session that make statutory changes, as I said in my training, we will look to see if there's any rulemaking associated with those legislative changes, and we will do rulemaking post session. This is in conjunction with the 4-year rule review phase 2, which we did not have an opportunity to complete when we first started it because of COVID and other issues. So what we are doing is we have gone through and done a painstaking review of all of the rules, and we have talked with all of the divisions and the programming staff who are involved specifically with massage therapy to get their perspective on some things that may need to be clarified or changed in rule. We are not looking at adding any rules at this time. If we add any rules, it will be done in conjunction with any legislative bill implementation rules that we do. This is simply to look at the rules for cleanups and clarification. We have found some areas such as sanitation that licensees and division staff have heard complaints about that need to be clarified or that we're consistently getting questions on. And so we're looking at those rules from the lens of a licensee who's trying to comply, and where we have instances where our compliance staff or other division staff are receiving questions that are substantially similar, we go back and we look at the rule and we say, that probably could be worded better. So we have just completed that process of speaking to all the divisions. Jonathan Parker and I have met. We have a preliminary plan of things that a grouping of rules that we would like to focus on. We have a rules group work group meeting scheduled for towards the end of May. At that time, we will present to the work group our thoughts on the rules and then give those board members who are on the work group the opportunity to give us input on what their suggestions for rule revisions are. Jonathan and I are trying to have a draft ready to actually present to the rules group, but it may not happen by the end of May because of workload and other obligations that we both have on other programs. So, but we are in getting close to starting to draft. We will get input from the work group on that. As I said during my presentation this morning, we will also present the work group members with drafts, final drafts of rules, and we will work with them to achieve a final draft of the rules. And then we will present those to the advisory board. And again, rulemaking takes approximately, usually it's 9 months to a year. We're going to try to get this done as soon as possible. We have a lot of rule packages and other programs that are moving as well. So we kind of have to, it's like a puzzle. We sort of have to puzzle things around and figure out priorities for rulemaking. But there are several areas, as I've said, that we have identified as needing to be priority in terms of rule revisions or clarifications. So that is the update on where we're at. At the next board meeting, I will give you another update on what we've done specifically with the rules work group, specifically with drafts, where we are in drafting. Are we close to a final draft, or are we, still massaging, pardon the pun, massaging the words of the drafts? I really did not intend to do that. It just sort of came out. But we will give you the opportunity to have updates as we move along in that process, because I'd like to carry you all along in that process so that you have at all times a full view of what we're doing and where we're at. So that is it for my presentation. But if you have any questions on it, I'm happy to take those questions right now.
I have a question. Perhaps this is for Anna, but when is that work group scheduled to meet at the end of May? Can you remind me, please?
I can as soon as I find it.
Okay.
I think it's May 10th, but let me double check.
Okay.
While Anna's looking that up, this is Heather Nussbaum. I have a question for the rule cleanup. I know you said you're not looking to add any rules, but I know I have heard comments before about some confusion where a rule may be listed and specifically identified as only applying to an establishment when the rule technically applies. Is that part of what you guys are doing as the cleanup?
Yes.
Okay.
So that work group meeting is on the 21st of May. Totally off.
Okay. All right. Thank you very much.
Yes, sir.
Okay, any other questions? Okay, moving right along, we have the appointment of the work groups. Since we have new board members, we need to change up the work groups to add them. Anna emailed everyone the list of work groups for the review yesterday afternoon, as well as in their packet last week. We can have 4 per group. And do we have any volunteers? Let me just go over what the groups are. It's enforcement workshop, the licensing workshop, the enforcement workshop to review and make recommendations regarding criminal conviction guidelines, the penalty matrix, and other enforcement related matters and rules. We have Russell Russ, Carol Willis, Antonio Gracia, and Kitra Taylor. Okay, there they are. Thank you. The next one is licensing workshop and review and make recommendations regarding licensing requirements and rules, inspections and compliance, and other administrative matters. We have David Lauderstein and myself. Do we have any volunteers for that one?
Callie Morris, I volunteer.
Okay, very good.
Heather Nussbaum, I'll volunteer as well.
Okay, very good.
Taylor, I'll volunteer.
Okay.
So we can only have
Educate
a total of 4 on that one.
4.
So we have Lauderstein, Guerin, Callie Morris, and Heather Nussbaum. Did you want to trade somebody out for Miss Taylor? That's up to you, Miss Guerin.
Not right now,
Okay,
if that's
so we'll
okay.
keep it at the first four. Okay,
Lauderstein, Garin, Callie, and Heather.
perfect. Thank you.
Okay, then we have education and examination work groups to review and make recommendations regarding education and examination, continuing education requirements and rules. And we have David Lauderstein, myself, and Russell Russ. We need one more there.
I'll volunteer for that one.
Okay, thank
Okay.
you, Ms. Taylor.
Oh, what was that? Taylor or Newspawn?
That was Ms.
Taylor.
Taylor.
Oh, okay. Very good. Thanks, Kit. Okay, and then standards of care workshop to review and make recommendations regarding the standard of care matters and rules. We have David Lauderstein, Kitra, and Caroline Garin, and we need one more.
This is Heather Nussbaum. I'll volunteer on that one.
Thank you.
Okay, thank you, Heather.
Let me ask, is it necessary for us to have 4 people? Because I'd be fine if called for to resign from the standard of care work group.
Okay, you are on 3 of them right now, so it's
Yeah,
up to you if you want to be on all of them.
not really. It's an honor, but I'd be happy particularly to volunteer to be off for the standard of care
Okay,
work group. If you want to take me off, that would be fine.
yes, sir. So we do have one more opening for that one, if anybody wanted to join in.
It's an exciting group, I have to tell
Any takers there?
you. I'll stay on if I have to, but it's not necessary
You
that I
may
be on.
have to, David.
Okay,
Well,
okay. I'm all right with that.
Mr. Lauderstein, would you want to stay on that one and get off of the licensing one so Ms. Taylor can be on that one? I know she had volunteered earlier.
Let me remind myself. No, I really would like to stay on the
Okay.
licensing. I feel a bit more attached to those issues.
Let me make a
Perfect.
pitch for the rules work group if this helps. That work group is a work group that is, I hate to say the most important, but I think one of the most important work groups that exists on this board, because you're going to have direct input into the rule drafts that are going to be presented for adoption. So it is kind of a powerful little group. And so I would really encourage someone, if they would like to carry the mantle from David, because it is a group that is really on the ground floor of what TDLR is working on daily. As it
You mean
affects your,
you're talking about the standard of care work group?
yes,
Uh-huh.
Yes, that's the rules work group.
correct.
This is Callie Morris. I will volunteer.
Okay, thank you, ma'am.
Or voluntold, however you want to look at it. No, I'm just kidding. But no, I think it would be a privilege. Thank you.
Thank you so much.
Okay. Thank
And
you.
I'll send these out this afternoon with a fresh roster as well.
Okay. Moving on, do we have any recommendations for the next board meeting?
This is Callie Morris. There was some changes for federal funding, and I just wanted to have us look at, ways to help to secure that. That we would, because we only require 500 hours, people would not qualify for federal funding based on the new rule that had come out by the Department of Education. So I just feel like it needs to have some attention and figure out what we can do to help secure people for financial assistance.
This is Heather Nussbaum. I have 2 things on that. One is a question of, is that a legislative to change those amounts, or is it something that can be done at a TDLR level? And the second one is, it does not actually disqualify them. It just disqualifies them for multiple options within it, but it does not completely disqualify them from financial aid.
Russell Rust here as well. I'd like to make a comment. As Heather stated, you can do financial aid for 500 hours. It just doesn't give you the advantage to add additional hours to it. And it is a legislative change. It is not something that the work group or the advisory board for TDLR would have any issue or be able to do anything with that.
Well-
Right, this is probably an issue that you should talk to your association about as we're heading into session. The one thing that I forgot to say during my presentation was associations, that is the way to, if anything is legislative, if you want those legislative change, it's important that you go through your association and have your association address those with their legislative folks, because that may be something that you all may want to pursue during the upcoming session. But any legislative changes, we do not make those, and we also can't like take a side on that.
Okay, I just wanted to make sure that that was at least brought to the attention and if there was something that could be done. So that was all.
Okay, any other recommendations for the next meeting? Okay, how about if we discuss the date, time, and location for the next board meeting?
So this will probably be after we have some work group meetings to get things started. So I will poll y'all for the next meeting.
Okay, very good. Okay, any other comments or questions?
No,
Okay.
Russell Rust, I make a motion to adjourn the meeting.
That was my next one. Thanks to everyone. The Massage Therapy Advisory Board meeting is adjourned and the time
Need a
is
second.
11:42.
I second it. And I want to welcome Carolyn to be the being the chairperson. Congratulations.
Thank you, David. Big shoes to fill here.
Yeah.
Yes, congratulations.